At the outset, I wish to thank Dr. Chauhan and his very energetic team for giving me this opportunity to say a few words to this distinguished audience of lawyers, hopefully law students and activists who intend to spend their career in the field of advancing the rights of socially and economically backward classes of society. Speaking for myself as a practicing lawyer, I have chosen to work for marginalized sections of society, and this naturally led me to investigate those provisions of the Constitution which would act as my tools in my journey to seek justice for the marginalized sections of society. This is how, over the years, I have been working for the scheduled caste and scheduled tribe community, more particularly in relation to their employment disputes. The Constitution of India is unique in the world in that way back in the year 1950, it provided for what we call reservations for scheduled castes and scheduled tribes in the matter of employment in services under the state. Why services under the state? Services under the state constitute an important branch of employment which gives us a share in state power. Now, these communities have been historically excluded from state power solely on the ground that they happen to be scheduled castes and for no other reason. When we talk about reservation, we are talking about the concept of representative institutions in our society. No society can call itself a democracy unless the institutions which enable the exercise of governance, which enable the exercise of power, which advance our educational and social rights are representative in character. And reservation was a means of ensuring that our institutions are representative. We as a democracy cannot accept institutions which are non-representative and still call ourselves, quote unquote, the mother of democracy. And this is the rationale for reservations. I would like to say a word of what I see as the distinction between reservations and affirmative action. While affirmative action may or may not be taken by the state in relation to education or in relation to services, guaranteed reservation under the Constitution of India is a fundamental right. It is unfortunate that our legal journey has remained unfinished because we still don't have a judgment of the Supreme Court of India which says reservations are a fundamental right. And why is it so? It is so because the Supreme Court has held that the rights under Article 16 are, quote unquote, enabling. But I have often argued that we must understand the meaning of the word enabling. Enabling is empowering. To say that something is enabling is surely on a par with saying that it enables the fulfillment of our fundamental rights. And therefore, to say that no mandamus can be given simply because Article 16 is enabling doesn't make any sense to me at all. So there's a whole lot of judgments of the Supreme Court of India which we have to work to either clarify or reverse before we can say that our journey is done. Let me come to another issue which has been highly contentious and which has been bothering us in the courts, and that is the question of promotions. Although the Constitution was amended to make reservations and promotions a fundamental right, and that too with consequential benefits, we have not seen the fruits of this reaching the working masses. And the reason for that is a judgment known as the Nagraj judgment, in which the Supreme Court said that before any such reservation can be made, there has to be data to show that SC and ST are inadequately represented. Now, the data is available. It's available, but it is not made available to the courts by various states. And on account of this reason, till today, the constitutional guarantee of reservations and promotions with consequential benefits has not been realized as yet. That is again another journey that we need to undertake before we reach our goal. However, at this point, I would like to switch to a different issue, but obviously a related issue. I have had occasion to deal with the question of atrocities against scheduled castes and scheduled tribes on several occasions. In particular, a case which arose in the Supreme Court known as the Gaikwad case, where a person from scheduled caste was denied a promotion. The facts of the case are vivid in my mind. Gaikwad was a storekeeper. He belonged to the scheduled caste. He had complained about corruption in the matter of maintaining of stores. Soon thereafter, he was presented with a show cause notice, a charge sheet, and denied a promotion on account of a finding, so-called, that his performance was below par. A case was lodged under the Atrocities Act by him. The courts denied him anticipatory bail, as the Atrocities Act does deny anticipatory bail to anyone who's accused of a crime under the Atrocities Act. When the matter reached the Supreme Court, a bench presided over by Justice Lalit and Justice Goyal granted the anticipatory bail and turned the law on its head. I remember at that stage, Mr. K.K. Venugopal was the Attorney General of India. He came to court. He presented statistics to the court on the kind of atrocities committed against SC and ST and the numbers. Some of these atrocities were ongoing as the case was being argued. And some of them were atrocities such as a bridegroom not being allowed to mount a horse, an SC person denied entry into a temple, and so on and so forth. He argued passionately that the judgment delivered by the court was incorrect and requested a review. Meanwhile, I had myself filed an application on behalf of Mr. Gaikwad to recall the judgment on the ground that a fraud had been committed on the court, in that all the proceedings before the High Court were not placed before the court. The judgment stood. After that, there was confusion among the SC and ST community. There was a huge outcry, and a demand was made to Parliament to once again amend the Act and ensure that anticipatory bail is not granted. The law was amended, and once again it was reiterated that no anticipatory bail can be granted in the case of a crime relating to atrocities against scheduled caste and scheduled tribe. Finally, this law was also challenged, but it was upheld, by a bench presided over by Justice Arun Mishra. But let me come back to the point that I wish to make. In my opinion, you see today a cry that there should be an end to reservations. And my answer to that is no, so long as atrocities under the Scheduled Caste and Scheduled Tribe Atrocities Act continue in India, till that time the provision for reservations for Scheduled Castes and Scheduled Tribes cannot be done away with. And perhaps even when atrocities end, reservations cannot be done away with for the reason that I mentioned earlier, namely they make for representative institutions. When we say we the people of India is sovereign, what we mean is all sections, all communities, all castes need to find a place in governance, need to have their share of power. This is the rationale for continuation of reservations, not that they have reached a stage where they form a creamy layer, so called, and therefore they don't need reservations. I would therefore once again like to thank you for this opportunity, but leave you with the thought that those of us who work on the issue of reservations cannot confine our work to only arguing for reservations in employment and in promotions. There is a world outside the world of employment, perhaps a more important world. There is a world outside Parliament. There is a world outside being represented in Parliament through reservations for SC and SC, and it is that world that we need to address. Unless organizations and welfare unions of SC and SC reach out to this outside world, join hands with their sisters and brothers who live in ghettos, who live in isolated communities, who live in conditions of apartheid, all our labor that we extend on the issue of reservations in court will lead us nowhere. A final thought. As you see today, there's a lot of talk about whether Sanatan Dharma is Sanatan Dharma or what is it at all, or does it need to be abolished, does it need to be done away with. I can only say from my limited reading of the subject, Sanatan Dharma is nothing but a so-called Dharma which upholds the very institution of caste. All I can end by saying is that Dr. Ambedkar's Annihilation of Caste should be compulsory reading for all persons in schools and colleges. He gave us the guideline. He did say that one way to end caste, but obviously not the only way, is intermingling and intermarriage between different castes and communities. We are very, very, very far from there. I'm afraid that right-wing forces have learned how to use the courts very effectively. We have not learned to use the courts as effectively as them because we, I think, have focused our attention only on the issue of reservations. Only yesterday I was reading a report in the Indian Express from which I learnt that cases from Tamil Nadu have arisen where scheduled castes and scheduled tribes are being excluded from becoming priests in temples, and the Supreme Court has entertained a petition saying that they ought to be excluded from temples if Sanatan Dharma is to be upheld. We have a long journey ahead. We are entering a period where we will soon in 2024 see an election, and I think this meeting has cut out a task for itself. Thank you, and I look forward to working with all of you.
MNT न्यूज़ नेटवर्क को सब्सक्राइब करें, लाइक और फॉलो करना ना भूलें। साथ ही बेल आइकॉन दबाकर जन जागृति की मुहिम में जुड़े रहें।